Form FL-825 is the judgment that finalizes a California summary dissolution filed on or after January 1, 2011. Here is how it works when the court signs it, and why the entry date is not the same as your effective date. What is Form FL-825? Form FL-825, Judgment of Dissolution and Notice of Entry of Judgment, is the California Judicial Council form that states the court's decision to end a marriage or domestic partnership through the summary dissolution procedure. It documents the date you become single again and tells both of you to comply with the property settlement agreement attached to the case. FL-825 covers both marriage and domestic partnership dissolutions, and it has separate checkboxes to indicate which one applies. It replaced the older FL-820 form for cases filed on or after January 1, 2011. FL-825 versus FL-820. Which one do you use? The form itself is explicit about this. Use FL-825 only if the joint petition for summary dissolution, Form FL-800, was filed on or after January 1, 2011. If your FL-800 was filed before that date, you would instead use Request for Judgment, Judgment of Dissolution of Marriage, and Notice of Entry of Judgment, Form FL-820. Because it is now 2026, this distinction matters almost entirely as a historical footnote. Virtually every current summary dissolution case was started well after January 1, 2011, so FL-825 is the form nearly everyone needs. FL-820 remains relevant only to the rare case where a joint petition was filed before that date, and the judgment still has not been entered. When you actually file FL-825, this is the detail that trips people up most. Based on the official FL-810 instructions, the sequence looks like this. You complete your property settlement agreement and required financial disclosures with your spouse or domestic partner. You fill out and sign Form FL-800, the joint petition for summary dissolution. You also fill out FL-825 at this same time, completing the caption, checking items 1B or 1C if either of you wants a former name restored, and filling in both petitioners' addresses on page 2. If you have a property settlement agreement, you staple it to the FL-825 judgment. Section-by-section walkthrough of FL-825. Here is what appears on the form itself. Caption and case information. At the top, you fill in the Superior Court and County, the case number if one has already been assigned, and the names of Petitioner 1 and Petitioner 2. Unlike the older FL-820, which used husband and wife, FL-825 uses Petitioner 1 and Petitioner 2, so it can apply equally to marriages and domestic partnerships. The court orders. This is the substantive part of the judgment, completed by the judge. 1A states the effective date the judgment of dissolution will be entered, restoring both parties to the status of single persons. 1B, a checkbox to restore the former name of Petitioner 1 with a blank to specify the name. 1C, a checkbox to restore the former name of Petitioner 2 with a blank to specify the name. The form also states that both petitioners must comply with any agreement attached to the judgment, meaning your signed property settlement agreement. Notice of Entry of Judgment. This second section is completed by the court clerk once the judgment is entered. It checks whether the entry is for a marriage or a domestic partnership, states the date the judgment was entered, and is signed by the clerk. A clerk's certificate of mailing on page 2 documents that a copy was mailed to each petitioner. The cancellation of rights notice. FL-825 includes a required notice explaining that dissolution can automatically cancel a spouse's or partner's rights under the other person's will, trust, retirement benefit plan, power of attorney, pay-on-death bank account, transfer-on-death vehicle registration, and joint tenancy survivorship rights. It does not automatically cancel rights as a beneficiary of the other person's life insurance policy. The notice recommends reviewing these documents along with credit cards, other accounts, and credit reports once your dissolution is final. Effective date versus entry date. Why the difference matters. FL-825 contains an explicit warning that is easy to miss. The date the judgment is entered, shown in Item 2, is not the date your divorce or domestic partnership termination is final. The date that actually matters is the effective date in Item 1A. That date is set by law to be 6 months from the date you filed Form FL-800, since California's mandatory 6-month waiting period still applies to summary dissolution, even though the process is otherwise simplified. The court may process and even sign your judgment before that date arrives, but the dissolution itself does not take effect until the date in Item 1A. What the judgment actually does. Once the effective date in Item 1A arrives, 4 things happen at the same time, based on the FL-810 booklet's description of this step. Your marriage, domestic partnership, or both is legally ended. The agreements in your property settlement agreement become binding, meaning you own what was assigned to you and you owe what was assigned to you. Except for what is in that agreement, you and your former spouse or partner have no further financial obligations to each other. You are legally free to remarry or register a new domestic partnership. Stopping the process before judgment takes effect, either spouse or domestic partner can stop a summary dissolution any time before the effective date in Item 1A by filing Form FL-830, Notice of Revocation of Petition for Summary Dissolution, with the Superior Court Clerk and mailing a copy to the other party. Filing FL-830 cancels the entire proceeding, including the property settlement agreement. Once the effective date has passed, FL-830 can no longer stop the dissolution. At that point, other legal options may exist, but you would need to talk to a family law attorney about them rather than relying on the revocation form. Common mistakes to avoid. Waiting until 6 months after filing FL-800 to prepare FL-825 instead of completing and submitting it together with your joint petition. Confusing the entry date in Item 2 with the effective date in Item 1A, and assuming your dissolution is final on the wrong date. Using FL-820 instead of FL-825 for a case filed after January 1, 2011, or the reverse for an older case. Forgetting to check Items 1B or 1C if either of you wants a former name restored, which means the judge has nothing to order on that point. Not stapling the signed property settlement agreement to the judgment before filing. If keeping track of all of this by hand feels like a lot, that is exactly what Virdix is built for. The wizard at Virdix.co walks you through these same questions in plain language and prepares your FL-825 for you. Virdix is a document preparation service, not a law firm. So this is not legal advice, but it can help make sure your paperwork is complete and consistent from the start.